Hello, my name is Sarah Valentine and I'm a corporate partner at Osborne Clarke. I also head up our technology sector. I'm joined today by Ian Hyde, who heads up our tax disputes team. Now, we're here today as part of Osborne Clarke's Disputes Week, and we thought it'd be really useful to talk to our audience about tax risks and why they're important. So Ian, before we start, I act for obviously a lot of corporate clients and also general counsel, and I have seen tax risks, tax disputes, etc. Why should the director, the general counsel, get involved in these and not just hand it over to the expert?
Yeah, well, undoubtedly tax is a technical subject. So you've got tax directors and finance directors who normally look after these things. But my take on it is that there are so many wider issues for general counsel and directors to care about beyond the actual Technical Finance Act. So at the moment, I'm looking at cases where we're making stock exchange announcements because of tax risk. We're enforcing indemnities against third parties, so contract claims. And we're also having battles about potential GDPR breaches. So those are all not tax issues, but they are related to the dispute.
Yeah, absolutely agreed. And actually, before we start talking about tax risks, tax disputes, I've been hearing quite a lot in the press at the moment about HMRC, a bit of negative publicity, and obviously they're under a lot of pressure to collect in tax after COVID. What are your thoughts on that?
Yes, absolutely. The revenue are under pressure. Government finances being what they are, the revenue need the money. That's what the revenue do. They collect money. It's also worth just looking at the wider picture as well. The courts have been taking a rather more aggressive approach recently to do tax avoidance, so that tends to be a problem for taxpayers. But also the revenue are pushing interpretations on things that we, as tax lawyers, previously thought were safe. It's what I call boundary pushing, that they are taking issues on points where everyone thought it was okay. So that's a challenge for corporates. It's also worth saying that the revenue don't have the resources to do what they should be doing. Now that is a problem for them, but I think it's a problem for our clients in that you don't get certainty from taxpayers very easily. It was used to have real-time working and things. That's gone. So there is considerable uncertainty now, and that can last for years because you can't get clear positions from HMRC.
Yeah, and that uncertainty is something I've really seen with our corporate clients. And this goes not just to not having certainty to be able to finalise your accounts because you don't know about tax risks. It can, mess up fundraisings. I act for corporate sales, as you know, and acquisitions, and I've really seen this in action where the lack of being able to get a quick answer has affected some sales. It has made some sales abort, and also for others that have gone through, they've ended up having to put a lot of money into an escrow. Buy side and sell side costs has to be covered. The uncertainty is really not good for a corporate if you're looking to do any type of finance transaction. So so tax risk, let's have a look about tax risk. Why should a general counsel or a director care about tax risk? Can you tell me a bit about that?
I think general counsel should be thinking of tax risk a bit like they think about health safety or cyber hacking or something. It's a risk that affects a business, so they should be thinking of it in risk register terms. So they should be thinking, not looking at the Finance Act, but thinking about what is the risk in a nutshell? What could derail that risk? What could materialize? How could that risk materialize in the business? What do you need to do to mitigate it? So working out that risk and understanding it as generally as the custodians of the risk register, that's the first position I'd say for general counsel.
No, I think that's absolutely right. They need to understand it, and obviously understanding that why it's important to understand that tax risk. What can they actually do to get involved?
Well, I think tax is a risk where a lot of things that general counsel naturally think about will affect the outcome. So things like evidence, without disrespecting tax directors, they tend to think about the tax. General counsel will think about, can you prove it? Because cases in tax appeals, you have to win on the evidence. So what is the evidence? What are you relying on to prove a case? I had one a few years ago where you'd win on the tax if you could show you had a commercial purpose. the business did not document commercial purposes. It took advice from the Big Four, so there were PowerPoint slides showing the tax strategy, but no evidence that there was a commercial purpose. So we actually had to give up, basically, because there was no evidence. So that's a general counsel type attitude that they tend to bring to the table. And collateral claims as well. Often a tax risk there will be an asset, as it were, of a right to bring a claim against a third party. Well, what are the time limits on bringing that claim? How do you manage that claim? Is it going to win? So if the assumption is in the tax team that there's no net tax risk to the business, is that true? So it's about kicking the tires and saying, what's really the risk here?
And hearing that, I absolutely agree. These are all the type of points and questions that would be asked and needed to be addressed in any type of commercial dispute. This is not just tax risk. Yeah, no, absolutely. Which I suppose leads me neatly on to tax disputes. Big area, technical. Can you tell me a bit about it without getting too technical on me?
Yeah, no finance acts. I think first of all, I think the really important thing, and I come across this quite a lot with general counsel, is to understand your enemy, understand the other side. The revenue are not a normal counterparty in any dispute or likely dispute. They are not commercial. They don't behave commercially. They are limited by what's called the litigation settlement strategy. That's a policy code that they had to create out of all the fuss that came from the sweetheart deals when revenue was seen as too close to business. Yep. So that limits their freedom to settle. It limits their approach to a dispute. So often a tax dispute is governed, the revenues approach is governed by policy. So they will say, on this bit of legislation, our policy line is to allow taxpayers to do X but not Y. And that can seem maddening to the general counsel, because they say, well, it's sensible to settle, but why aren't the revenue settling? We're offering them, whatever number. Yeah. But they won't, because they have a policy line. So you have to navigate your way around that in managing disputes with the revenue. I think also that means settlements are rarer. Yes, you can settle with revenue. The revenue have a policy to mediate. In the sort of corporate disputes you and I would come across, that's very rare, because it's not a sort of small matter of forgetting to disclose accounts or something. It's corporate risk. So I think those issues, and also back to the point about resources, the revenue are always slow. I often get this from general counsel. Tax directors understand it. General counsel don't, which is it will take a long time for the revenue to work through a dispute. So you have to be prepared in the business for a long slog.
So do they ever settle, or are you telling me they always go to dispute, appeal, etc.?
No, they do, but you have to, and I've mediated with the revenue, but you have to take into account that policy point I talked about, that you have to work out what they can settle on and what they can't, and then engineer your settlement offer to meet their policy objectives. So it's a bit of a dark art to find out how to settle.
So coming on to tax disputes, how do they start, and what kind of is the information, etc., that's going to be needed?
Yeah, well, obviously, I mean, a dispute will start because the revenue think you're not paying enough tax. Now, and that may be because they've looked at your accounts and your tax returns, or they've got information from a third party that means that they think you're not doing the right thing. I think, without getting into all the complexity of the different types of dispute, a general theme I would have is that for general counsel to think about is that the revenue are always acting under statutory powers. They can only do what they can do because an act of Parliament allows them to do it. And a good example of that, I think, is the information powers one. If you're, maybe I'll cover that as an example. Yeah. So the revenue will often ask for information, data, documents, information on stuff, and they are borderline obsessive about asking for information, and they go through a lot of stages of asking for information. But they only do that through statutory powers. So often they will, or sometimes, they will exceed those powers. And if they do, they're acting ultra vires. So I mean, there's a lot of detail here, but general counsel should just be aware of that. It's sort of an example of where that where that can happen. So if you're handling one of those disputes, just think about, are the revenue asking for too much? Are they breaching their powers? It's also good to record the method you're applying in working out those powers. So if the revenue are asking for 10 years of information, you say, well, hang on, you can't ask for 10, you should only ask for 4. Or you only search for 4. And it's a litigation thing, a general litigation thing that you GCs will be familiar with. But also, other issues come up here, such as privilege. Is it privileged? GCs will know about that. It's a GC area, not a tax director area. Also GDPR, that is a common issue we're coming across, and we've discussed this before, that you can only hand over information to HMRC if it's a lawful exercise of lawful power. So if you hand it over voluntarily, so perhaps you want to keep a good relation with HMRC, you just give them everything they ask for, well, that could be a breach of GDPR because it may be personal data on your customers or your staff or something like that. And that, as I said before, that is a real issue. So as an example, it's just watching how you do it. And none of those are particularly the things that will resonate with GCs if they get involved.
Yeah, I think that GDPR point's a really interesting one because it's a very difficult balance to get. You know, you've got to make sure, as you say, you're handing over the information, but with that eye and mind on the fact that you cannot breach the GDPR rules. So a difficult one way, and that's why I do see GCs should be involved in this type of dispute. No, that's great. So if that dispute then turns into basically an appeal that's going to the tax tribunal, tell me a bit about that. I've not seen many of those, so it'd be interesting to hear a bit more about that.
Well, obviously there's a core tax question, there will be, but a lot of cases are won or lost on the facts. So a GC's eye, the training of a GC, the mindset of a GC is much more suited to saying, well, okay, the burden of proof is on us, as it is in the tax tribunal. The burden of proof is normally on the taxpayer to prove facts, balance of probabilities. Can you prove it? You know, I've had cases where it is assumed that you can prove the facts. The tax team have assumed you can prove the facts. But the managing director, who knew everything about that reorganisation, he retired 3 years ago. So suddenly you can't find him, you can't prove the facts. Well, I think GCs should be kicking the tyres on that sort of thing. So, well, before we go into this tribunal process, can we prove the facts? Even if we're right on the law, we could lose. So those sorts of things. Merits of the case, and that's a very technical thing, but it is just worth going around the houses and checking that the merits aren't based on the tax advisor who put the scheme in place in the first place, and they're not marking their own homework, because that's really, once you go to tribunal, that's not good enough, because somebody else, the judge, is going to say, no, actually I disagree with you. So just checking where's that merit view come from. Also, I think, come back to the third-party claims, tax tribunals take a number of years. We're back to the revenue being slow, tribunals slow, it's a process. It'll take a number of years. Where are we on those collateral claims, those indemnity claims? Are the Limitation Act issues going to come up? Do you need standstills? And this happens all the time. You have to put standstills in on the collateral claims to preserve them whilst you go to the tax tribunal. So some thinking around that, general counsel thinking. I'd also say think about this from a wider business perspective. Is the business comfortable with another few years of uncertainty? Are they going to sell the company? What do they want to do? Are they fundraising? Are there things that are going to happen in the life of the business where that continued uncertainty is going to create issues? And GCs have that perspective, in my experience.
Yes.
And also a final point, hearings tend to be public. Is the business comfortable with that? Washing linen in public?
Generally not, no. Exactly.
Yeah.
Ian, that's been a really, really helpful summary of tax risk and disputes and also appeals. I know we're kind of slightly running out of time. What would be your top tips for basically GC in this area, just so that kind of summarise what...
Yeah, I think don't stress about the fact it's a Finance Act. These are disputes, and GCs know disputes generally. So get an understanding of what those risks are, understand where the pressure points are, understand what you're going to have to prove. Is it really credible? What is the third party position? Do you have customers where you're going to have to go and talk to them if this issue goes wrong? All those sorts of things. Get that wider perspective even before it becomes a tribunal matter. And if it does become an appeal, get on the steering committee. Just get involved, elbow your way in, because you will have skills as a general counsel that the tax team will not have. So understand the evidence. Really sort of, should we be doing this? And what about the wider business? I think it's the wider business and understanding it in context that time and again GCs can do. And tax sometimes miss some of that, I would say.
Yeah, no, I understand. I think that's been incredibly helpful. So thank you, Ian. That's certainly helped me understand it, and I hope that's been very helpful for our audience too.
All right, thank you.